So panel one, we spent so much time talking about the articles and why they failed. And among their numerous failures were representative issues, taxes, lack of coercion from the federal government, and an inability to really coalesce around issues of national importance. So coming out of, actually I'm going into the first question. I should actually introduce the panelists. First, we have Professor Kermit Roosevelt. He is at the University of Pennsylvania School of Law. Next to him, we have Professor Gienapp, Jonathan Gienapp. He is a historian and law professor at Stanford. And last but not least, we have Dr. Cost, a historian and non-resident fellow at the American Enterprise Institute. Back to the question. So coming out of the articles, dealing with great distrust for centralized power, dealing with a body politic that was agitated by centrality of power, how did the framers of the Constitution, the individuals that wrote it, convince the American public to give the central government even more power?
Well, so I think that the failure of the articles was pretty evident to people. So, you've got elite opinion and you've got public opinion, but you've also got just sort of the material conditions that people are facing. And I think, Shays' Rebellion brings home the extent to which you don't have a national government running things within the United States. And conflict between states, there's actually a brief war between Maryland and Virginia over oysters. The inability of Congress to tax and to support an army. All of this, I think, made it pretty clear to the general public that there were problems. And then the question is, what form will the solutions take? And one of the things that we're talking about, I think, is the extent to which the Constitution builds on rather than just replaces the Articles of Confederation. And I think one of the reasons that the Constitution was easier to sell was it wasn't a repudiation of the Articles. So, the revolution, that's a repudiation of monarchy. They're like, there's something fundamentally wrong with our governing system. We've got to change it drastically. You could say they weren't rejecting the legitimacy of monarchy as an idea. If you had a monarch who did protect your natural rights, that would be okay. The problem was it didn't work out. King George is a tyrant. We don't trust kings anymore. We're going to do it differently. But the relationship between the Constitution and the Articles of Confederation is not a repudiation in that way. And you can see that in a couple of ways. One, they preserve debts going forward. So they're saying, we had the Articles of Confederation, didn't quite work, we're going to change it, but we're still the same United States. Debts that were incurred under the Articles are good against this new constitutional government. And also they say, it's a more perfect union. We're not rejecting the Articles, we're just improving on them. And maybe sort of the simplest way to explain that, I don't want to go on for too long, but is to say that with the Articles of Confederation, they understood we're 13 United States, and being united means we have to sort of speak with one voice in some capacity. And basically, that's the outward-facing sovereign, international relations. So the states aren't going to declare war on their own. If the United States is at war, we're one nation, effectively. They weren't a nation, but we're a confederation, but we're all going to be working together. And then what they realized with the failure of the Articles was they needed more of an inward-facing national sovereign too. So they needed a national government that could give you uniform laws on some topics and that could stop the states from fighting and that could make it more of a union for domestic as well as international purposes. But I think a lot of what was going on was this sense, we're improving things. It's not another revolution, even though it is illegal, right? It violates the Articles unanimity requirement. But it's not a rejection of the prior order, it's an improvement.
So first I'll just say what a pleasure and privilege it is to be here. It's always wonderful to be at the National Constitution Center and continue my collaboration with the Brennan Center that is now several years long. So to the question of sort of what's on people's mind in 1787 and how are they trying to sell it, I think sort of front and center is the idea that this federal system that has emerged in the wake of the Declaration of Independence lacks the necessary energy and in two distinct senses. So the first one is the relationship between centripetal and centrifugal force. So the way to think of this is you have separate states, you have these collection of things on the periphery and something in the middle that's trying to hold them together. The analogy they often use, they use it a lot at the Constitutional Convention, is thinking of the federal system like a solar system. How do we have the right gravitational pull toward the center such that the parts don't fly off? And this had been the deficiency of most confederacies through history. Centrifugal force had been much stronger than the centripetal force, and therefore the parts broke apart and you got disunion. So how do you concentrate more energy at the center to hold the whole thing together, to think of it as a system that will actually work and not constantly be at war with itself? Well, part of the way you do that is the second way in which you need to endow this system with energy, which is give the national government more of a capacity to do things. This has been a major problem both during the war and thereafter to address the problems coming out of the war. Very little executive capacity to actually act and address these emergent problems. So one thing that was really necessary is, as we were talking about in the first panel, we have this sort of anomalous single-body government, more like a diplomatic body. We need to replace that with an actual genuine government with 3 independent branches that look like the state governments, that also have independent authority to act. So it doesn't all run through the states. So it either represents the people directly in some fashion and is legitimated by the people directly in some sense. Only that can give the federal government the energy needed to act and address problems that are emergent that will sort of hold this system together. But they often thought of how they were building or refining a system and presented it to the American people that way, as opposed to writing a legal code. You know, we're trying to build a system that is going to have, at this point, 13 states and 1 union, and how are we going to ensure that the 13 don't rip apart the 1?
So I would say the salesmanship of the Constitution to the people is one of the most brilliant political maneuvers in the history of the United States of America. And I would point out at the outset that the message calling for a federal convention did not call for a new constitution. It called for a reform of the Articles of Confederation and a revisal of them to make them adequate to the exigencies of the Union. Well, what exactly does that mean? Well, this is where a handful of what you could call nationalists, or who would later be identified as Federalists, seize the initiative and set the agenda of the Constitutional Convention. This is particularly evident in James Madison in his efforts in the winter and the spring of 1786 into 1787, helping to create a system of government known as the Virginia Plan. And Madison comes to Philadelphia early. He comes at the beginning of May in 1787. The convention didn't get a quorum until the end of May, so he's coordinating his actions with the other delegates from Virginia and possibly the Pennsylvania delegates as well. And so when the convention opens, Edmund Randolph says, here, let's talk about this plan. In this plan, the Virginia Plan was not a revisal of the Articles of Confederation. It was a complete elimination of them. It was basically a do-over. And what happens throughout the next couple of months is they edit and they debate and they revise and they re-revise. But that initial seizing of the agenda and orienting the convention towards drastic reform rather than something more modest is really important to understanding what happens. And then on top of that, the convention is debating in private, in secrecy, which is for the most part maintained. And then in September, here is this document. And I would say that there's a couple advantages that they had. The first is the United States Senate. The United States Senate is an incredible incentive to the small states. Thinking of Connecticut, Georgia, although Georgia's territorially large, it's small in population, Maryland, Delaware, New Jersey. This is an incredible bargain for the small states, to have all of the securities of a national union combined with protection in the United States Senate. So it rolls through ratification in large measure because of these small states. And finally, it doesn't really hit a snag until Massachusetts, But by that point, it's already picked up so much momentum. And Madison, in the Federalist Papers, says, this is the argument that we're facing. Imagine you're a sick patient. You're sick, and you're going to die. And there's a doctor who says, this is what you need. And there's another doctor that comes in, somebody else comes in and says, oh, no, that'll kill you. Don't do that. Whatever you do, don't do that. And the patient says to this other doctor, oh, what do I do? And he doesn't have an answer. And so what's the only reasonable choice is to do the doctor that offered a prescription. And indeed, I think this is another feature here as well, which is that those individuals who would become what we know as the Anti-Federalists are not meaningfully taking part in the convention. I mean, there are some there, like Luther Martin, but the two Clintonian delegates from New York, they leave. Patrick Henry doesn't come. And so you don't really see meaningful anti-Federalist movement really until opposition to the Pennsylvania's ratification of the Constitution. And so really what you get then is, in theory, the country, I think, might have accepted something like the New Jersey plan if that had been presented. But the nationalists, the Federalists, seized the initiative such that what was presented to the country was the Constitution.
Thank you all for that. Following up on a thread from panel one, we spent a lot of time talking about the importance of localism, republicanism, and it made me think of this concept that was raised during the Constitutional Convention debates, the concept that a state precedes any constitution, and therefore the state is completely independent and can operate in a way that might be different than the federal government. But then I read the preamble of the Constitution, and thank you to Professor Gienapp for recommending that, which says that we, the people, create a united states, right? So in the first opening words of the Constitution, we're repudiating that idea. And so I'm curious, thinking now to, various constitutional arguments regarding the scope of state power, what does the preamble tell us about the concept that a state is or should be sovereign simply because it existed temporally before the United States Constitution?
Well, I think that's a very interesting question. I mean, that's one of the perennial questions of our constitutional history. What's the relationship between the nation and the states and the people? And because it's one of the perennial questions, I would tend to say this is something that people fight over. This is something that inevitably we're going to fight over, and there is no definitive resolution. And then sort of as an illustration of that point, I'm going to say, okay, let's look at the preamble. What does the preamble say? It says, we the people of the United States. Okay, so that certainly does sound like here we've got a single national people who are the ultimate sovereign, creating the Constitution, and wow, the states are sort of cut out of it because the power comes from the people. But if you go back and look at how it was actually drafted, it did say, we the people of the United States of Rhode Island and Providence plantations and North Carolina, Massachusetts, and they listed them all. And that makes it sound more like it's the people in the states, and now like the states are sovereigns. They took out the actual enumeration of the states because stylistically it was awkward, and it would be embarrassing if some of the states refused to ratify, as of course Rhode Island initially did. So even there in the preamble, I think you've got this fundamental ambiguity. And I think that a lot of my growth as a constitutional law professor has been realizing that there just are fundamental ambiguities. There are things that people did not agree on at the time. I used to sort of think of the Constitution as this secret code, sort of like Nicolas Cage, National Treasure. If you can figure out what the mystical incantation and cipher is, then all of the right answers are laid out before you, and it's objectively true, and you're just correct. And I don't think about it that way anymore. I think that there are issues that people argue about, and they resurface again and again in different guises. And some of them are just focal points for disagreement, which I think is not necessarily a bad thing, because a lot of these issues, the American people get to work them out. And we've got vague and poorly defined concepts in the Constitution, and the American people, through ordinary politics or just the ordinary interactions of ordinary life, get to sort of define our constitutional values and figure out what equality means to us, or how the nation and the states should interact. I mean, there's a lot of interesting history to be discussed. So the states, Abraham Lincoln said, didn't precede the Union because it was Congress that told the states, write your constitutions, now you're states, you're not colonies anymore. That's true. The states did certainly precede the Constitution, and under the Articles of Confederation, they do seem a lot more like independent sovereigns. Before the Articles of Confederation, after the Declaration of Independence, they are fully national sovereigns with the power to make and conclude war, and all of the things that states may of right do. So they start out as full international sovereigns. They surrender some of that sovereignty. They accept some restraints under the Articles. They accept more restraints under the Constitution. But this whole question of who's the primary sovereign in the American system and sort of do you trust the states more, or do you trust the national government more, that question will never go away. And also, I think, one of the reasons that we're more interested in the Articles of Confederation now than people were in, say, the 1960s with the Civil Rights Movement, is that over time, who's the good guy in the American system, that changes. So, sometimes the states are the good guys, and they're standing up against the national government. That's the revolution. Sometimes the states are the bad guys, and they're standing up and defending slavery. That's the Civil War. Sometimes we like Congress, Reconstruction, Congress versus Andrew Johnson. Gee, I like Congress there. Sometimes you like the president, maybe. Sometimes. But ultimately, I do think the ultimate sovereign is the American people, and I think ultimately the American people have to decide how to make the system work the best they can, or if it's not working, to change it.
So building more or less directly off of those very nice remarks, I mean, in many ways, this is the question. Before you figure out how to govern yourselves at the time of the revolution, you have to answer the question, what is the United States of America? Who are we? And it's not an easy question to answer, because some people emphasize the unity of the nation and the American people together, and others say what we definitively are a set of more or less autonomous individual states, different kinds of peoples that are going to confederate together, come together under certain kinds of agreement. And this hinges on competing interpretations of the Declaration of Independence that is ambiguous in this regard, because it, on the one hand, refers to one people, a collective that declared independence, but also talks about how it's establishing and therefore is speaking for free and independent states in the plural. So to figure out what the Articles of Confederation says and can do, and then what the federal Constitution says and can do, requires first answering this question. Who does it speak for? What kind of a political entity does it represent? The Constitution as a form of government presupposes the Constitution of the federal union itself. And the preamble is one of these sort of key touchstones that was purposefully written the way it was by leading nationalists, James Wilson and Gouverneur Morris above all, because they were really eager to make it clear that it is not we the states and it's not we the peoples of the United States, it is we the people of the United States, a single collective entity. And part of the reason why is because of what James Wilson, a leading nationalist who always emphasized the nation over the states, said in the convention when he had a very interesting debate with Luther Martin, a leading defender of states' rights, in June of 1787. Luther Martin says, the states came first, the chicken and the egg problem. The states came before the Union. We were put into a state of nature by the Revolution. The states created separate governments, and we then confederated. The states are primary. They came first. James Wilson responds by dramatically pulling out a copy of his Declaration of Independence and saying, you have it wrong. The Union preceded the states because we declared independence together. This is essentially a dress rehearsal for what Jefferson Davis and Abraham Lincoln will argue about in 1860 and 1861 about the origins of the Union. So if you ask someone like James Wilson or Gouverneur Morris or the other leading nationalists, they would say the preamble is proof positive that what underlies the US Constitution is our first Constitution, which is not the Articles of Confederation, but the Declaration of Independence that establishes a single nation, a single people. And this was actually how they interpreted the Articles, to suggest that the Articles gave the national government significantly more power than a lot of people thought. But they weren't alone. Other people had different views on this subject. Other people said, no, the Declaration of Independence created a multiplicity, not a unity. The Articles of Confederation, most important provision is Article 2 that says, each state's sovereignty, independence, and freedom shall be retained unless expressly delegated to the national government. And they would point to not the preamble, but the eventual 10th Amendment, which is among the things that the Anti-Federalists call for, which says that all powers not delegated to the federal government are retained by the states or the people. But then the nationalists like James Wilson would say, it says delegated but not expressly delegated. Because that is a callback and a reminder of what the preamble is alluding to, which is this nationalist reading of the Declaration of Independence. But there weren't easy answers to these questions in 1776 or 1781 or 1785 or 1787 or 1791. The United States devolved into civil war in the 1860s in many ways because there were competing answers to these questions. And as Professor Roosevelt was suggesting, those questions resonate still to this day. That was the first question, and in some ways it's still the question.
Yeah, so one of the things I like to tell my students is that politics is not math. So if you're bad at math, then maybe politics is the subject for you. And my reasoning here is that in math, 1 + 1 can only equal 2, right? It can equal nothing else. One is greater than 0, 2 things have to be equal. Well, that's not really how it is in politics. I mean, you can look at our persistent debt and you can sort of see us collectively just ignoring the math problem there. But more than that, right? What are we? Are we a national union or are we a federation of states? These two things are very different from each other. And yet when you look at the Constitution, we're kind of both. Right? And you can sort of see the push and pull within the document on matters like this. So you can see, for instance, the preamble, which was written by James Wilson and Gouverneur Morris, as being very nationalistic in the Committee of Style, right? But when John Rutledge produces the rough draft of the Constitution, he creates enumerated powers, right? He gets, the convention had preliminarily voted on essentially giving Congress plenary power to do whatever was necessary for the national interest. When the rough draft is produced, it's an enumerated power, which by implication means that the federal power is limited. You can look at the House and see a national union there. You can look at the Senate and see a confederation. Even the way in which ratification occurred, right? It was ratified by 9 states, which suggests a kind of confederation. But it was ratified by special ratification conventions elected directly by the people. Right? So it sort of swirls through the Constitution, this tension, and it swirls through our history. I mean, you can look at the Kentucky resolutions of Virginia and see that as a bold stab at limiting federal power. And you could look at the quids, the tertium quids of the 1820s, thinking back to the good old principles of 98. You can look at, on the flip side, you can look at Jackson's response to the nullification crisis, specifically citing the preamble, saying states cannot do this because they created a nation. And again, you can see it in the Civil War. You can even see it nowadays too, continuously. I mean, since the Rehnquist court in the 90s sort of began using the 10th Amendment to strike down federal laws, it raises questions about the specific scope of federal and state power, which brings us back into this sort of almost an ontological question that doesn't admit of a clear answer.
So you all described ambiguities within the design of the Constitution that make it difficult to answer a question about, the scope of state sovereignty. I want to ask yet another confounding question that is very specific to Article 2. So, there are several theories about the scope of executive power that are supported by various statements that individuals made during the constitutional debates. And one thing that I found striking is, James Madison, that we all love to refer to, the father of the Constitution, he says, essentially, the executive is just a person. We have a person here that's going to execute the law. Clearly, his interpretation did not rule the day. And so I'm curious what you all believe that the constitutional debates say about presidential power. And, is our current model, where it seems like the president has sort of aggrandized a lot of power over the years, of course it's been given by the court, and in some senses Congress has delegated that power, but is the system of our presidency, is the way that it's working at all similar to the way that it was perhaps intended or envisioned to work?
So I would say, again, different people envision different things, and different people hoped for different things, and we've seen a bunch of different things happen. And I guess, one of the luxuries that we have now with the historical record that we have is we can look back and we can pick, maybe examples that we like and say, the president should maybe behave more in this way than in that way. But I do think that we should understand that the constitutional design has produced this accretion of power in the presidency in a couple of ways. So one is something that the framers certainly did intend. They understood Congress is a multi-member body. It's got two houses. It's a lot harder for Congress to act. So you do want to have some capacity in the government to respond with energy and dispatch, to handle crises, to get things done when necessary. That's the executive branch. The power is consolidated in one person. They did that deliberately. So the idea that you're going to have executive power concentrated in one person and that person is going to be able to be effective, that's part of the design. If you think about the president versus Congress, though, they anticipated, of course, checks and balances. That doesn't work out the way that they expected because of the party system, which sort of notoriously they didn't foresee. So if you've got two parties and they're fighting for control of the government and they're sort of relatively equal in the support that they command, what's going to happen? Well, one party will win the presidency, and that's the executive power concentrated in one person, wielded by that party. And then on the other side, you've got Congress, which is divided, and it's hard for Congress to act anyway. And we've got, the filibuster in the Senate, which is not in the Constitution, but we've got all sorts of things that make it harder for Congress to get things done. It's sort of natural that the president is going to come out ahead in most of those struggles because the president has not only sole control of the executive branch, but also a lot of allies in Congress, members of his party. So you can expect that the president is going to do pretty well when contesting with Congress. But all the same, right, we've got a lot of choke points and veto points in the system, and those are designed, again, in part, intentionally. Right? Separation of powers is supposed to protect individual liberty. You need all the branches to cooperate generally before the government can put you in jail. Congress has to pass a law saying you can't do something, and then the executive branch has to prosecute you for doing that, and then the judges have to agree that you in fact did it. But again, once you introduce the party system, it turns out that all of these veto points in the system make it really easy for one party to stop the other party from getting anything done. So, you win the presidency, but you've got these opponents in Congress. Maybe they can still stop you from getting something done. And then people start to think that the government is broken, and then they start being susceptible to the demagogue who comes along and says, I alone can fix it. So again, I think our Constitution, coupled with the party system, does bear some responsibility for the problems that we're facing now.
So as perennial questions of American constitutionalism go, certainly what kind of presidency was imagined at the beginning? How did people understand executive power at the beginning? Not least because the presidency has become this astonishingly powerful office across time. I think the way to sort of begin orienting this is American political attitudes in the 18th century were deeply shaped as living in the English-speaking Anglophone world and feeling as though they were, as members of the British Empire prior to the Revolution, heirs of the English constitutional tradition, to the great constitutional settlement of the 17th century, which had been an epic showdown between the prerogatives of the crown, the king's ability to act freely and do as he wished, against the privileges of Parliament. And in the Glorious Revolution of 1688-89, it's been a decisive revolution that Parliament had prevailed, that the sort of king's discretionary authority would be cabined under parliamentary control and law. So to a lot of people in what was referred to as the Whig political tradition, which deeply informed American attitudes, an executive was simply that, a mere executive. President as errand boy. Somebody else provides the instructions, and the executive carries those out, carries out somebody else's will. So this is why in the state constitutions in 1776 that are initially written in 1776, the chief executives, the governors of the various states, have very, very, very little power because it's seen as antithetical to Republican liberty, and it smacks of monarchy, of the worst kind of monarchy. What was the point of fighting a revolution? Just to concentrate executive power. We're going to have executives as errand boys. The legislature that best represents the people are going to design actual policy, and then the executive merely carries them out, sort of like a power of attorney. They don't have a free hand, they do as you tell. But the problems of the 1780s under the Articles of Confederation had led some people to think that this misbalanced things. They didn't necessarily repudiate the concern about executive power, but they thought that legislatures that had all that power, the impetuous vortex, as James Madison put it, they're able to pull in so much authority, can themselves become tyrannical. So you need to come up with new ways to potentially check them. And one advantage would be to fortify the executive in new sorts of ways, potentially by reviving what a lot of people in this political tradition thought was extremely dangerous, which in giving the executive things like a share of legislation, right, through a veto power. This made the executive a part of the legislative power. So there were a lot of people at the Constitutional Convention who were very interested in that kind of presidency, a presidency that would not be extraordinarily weak and errand boy-like, under the states, but would actually have independence and a free hand. And they really defended this view of the presidency, that there would be a veto power, appointment power, commander-in-chief power. There would be an ability to resist Congress and actually do things. But the other question is, did they mean things beyond that? Did they mean for executive power, what is vested in the president at the beginning of Article 2, to mean an enormous swath of power that would provide the president really an extraordinary amount of authority and independence? And I think a lot of them were interested in a very strong president from the perspective of the state constitutions in the 18th century, but did not have in mind the kind of presidency that has come to predominate. But they put in place a system that ended up creating the dynamics that made it very easy for the presidency and the executive, for reasons Kim was talking about, to pull it towards its orbit. Alexander Hamilton realizes this as day one as Secretary of the Treasury, that the executive branch has first mover advantage. And James Madison goes from saying, I thought the big problem in Republican politics was that legislatures pull in all the power and we're just trying to resist against that kind of concentration. Alexander Hamilton under the Washington administration has shown me that actually executive power can be really robust and muscular in a Republican system of politics, and begins rethinking how he thinks about these things. Because the president has a capacity to act through executive authority where Congress is mired in debate, and especially in foreign affairs. And the United States finds itself in having to deal with the wars precipitated by the French Revolution in Europe. Are we going to stay neutral, or are we going to get involved? And it allows the Washington administration to say, hey, we basically set foreign policy. We're going to take the lead on this. So the growth of presidential power was not necessarily anticipated or expected, even by people who thought it was really important. But in a lot of ways, it's right there in the system of what Article 2 unleashes.
Yeah, James Madison was certainly surprised in 1790 by the newly emergent power of the executive branch. As a matter of fact, in 1789, he had worked to actually beef up the power of the executive against what he continued to fear would be an overawing congressional influence. So, for instance, it was Madison in debates over the State Department. Does the president have the power to fire the Secretary of State? Madison was a leading advocate that, yes, that's inherent in executive power. Another and this is very ironic as well. It was Madison who sort of, like, some people were skeptical about having the Secretary of Treasury submit proposals to Congress on the state of the public credit, because they worried that that would be too much executive influence over Congress. Madison waved that away, and it was those 3 reports that Hamilton produced from 1790 through 1791, the first 2 reports on public credit and then the report on manufacturers, that the potential of the presidential agenda-setting power became evident to Madison. And so what you see then, as a matter of fact, a continuing debate, sometimes in the subtext, but often in the foreground, is between the 2 parties, is the scope of presidential power. This is one of the reasons, for instance, that Thomas Jefferson ends the tradition of given a State of the Union address to Congress, which had been done in person by both Washington and Adams. This is where you get the initiation from Jefferson up through Taft of a written State of the Union address to Congress to sort of push the president into the background. And I think another thing to bear in mind as well, when we're talking about inherent executive power, presidential power, I think you cannot underestimate the political importance of the democratized presidency. And the presidency in 1789 was not democratized. Now, for sure, there were some states that did have elections for, say, like electors. Virginia voted for electors. But it wasn't really until the 1820s and then into the 1830s where, with I think the exception of South Carolina, you have the entire country voting for president. And so you get this really remarkable twist of things. And a good illustration of this is when Madison is president and he's trying to sort of like work through the crisis with Great Britain, his attitude is, I have to wait and see what kind of tools Congress is going to give me to negotiate, because Congress is the popularly elected branch. But then in 1830, when Andrew Jackson is president and he discovers members of Congress are opposing him, his allies, he says, send them home and see what their voters say for defying my suggestions. And so the democratization of the presidency is something that happens in stages. And it was democratized, but then almost as soon as it was democratized, it was sort of grabbed by these party organizations for almost 100 years that sort of constrained the presidency. But now the presidency is unconstrained really by the Electoral College or by party organizations. The presidential nominees are democratically elected. The presidential election is democratic. And so the president is able, in ways that the framers would not have probably imagined, able to claim the mantle of democratic tribune, right? Going back to ancient Rome, the tribune is the spokesman of the plebeians, right? And the president can say, I speak for the country. It's a very, very formidable political power.
Thank you. And just a reminder to the audience, if you all have questions, please write them down on the note cards on the table and hold them up so that we can address them. So I've got a handful of audience questions here. I'll start with this. Can you all talk a little more about the Constitution's fundamental ambiguities and how they relate to the country's current struggles?
Small question.
Small potatoes.
Well, I'm happy to, I mean, there are 2 levels here. So one is the ambiguity of particular aspects of the Constitution, particular phrases. So for instance, Article 1, Section 8 establishes a set of enumerated powers, and certain people say, well, this establishes the sort of principle that the federal government will be of a different kind than the state governments. It will not have sort of broad governmental plenary power. It will have to work off of an enumerated list of power. But it's punctuated by the necessary and proper clause that says that Congress can also make all laws necessary and proper to carry out not just these foregoing powers, but all other powers vested in the government of the United States. So there's a central ambiguity there about what exactly is pulled in by this clause that comes at the end of the list. If somebody says, you can only do these 10 things, if you tell your children that, or you make a list and say, this is the list of things you can do, and you can also do anything else that is necessary and proper to kind of carry those out. That creates a lot of ambiguities. But there's a bigger ambiguity that's on the table, which is, what even is the United States Constitution, and how should we interpret it? Is it alike in kind to other sorts of things that we have some sense of how to interpret? Is it alike in kind to other sorts of legal instruments like statutes or contracts or treaties? Or is it very different because it's a different kind of instrument rooted in popular sovereignty rather than ordinary law? Is it a document that's supposed to be, an instrument that's supposed to be completely finished in a sense, that it sort of speaks to all sorts of questions, if only through implication? Or is it kind of unfinished by nature, sort of calling to either future generations to, it's just sort of the framework of a building, and it's to future generations to keep building it out in a big way? Or are things like the Article 5 amendment feature there, not just in case things need to be changed, but as a call to continue doing the work? The sort of big first question of its ambiguity. What are we even reading? What does it even mean to interpret and construe a constitution and carry it into effect? Is a big source of ambiguity that's never gone away. People often debates over specific parts of the Constitution are really being governed by big debates in the background about what it even means to have a Constitution and to be bound by one.
Yeah, I actually want to follow up on that thread and go back to one of my questions. Sorry, audience, personal privilege for a minute here, and talk about expounding, interpreting the Constitution. Professor Peterson, I'm not sure if she's still here, but she wrote a really great paper that argued, during the founding era, we interpreted public law equitably, and the Constitution is a public law document. It's not, doesn't have the prolixity of a legal code, as McCulloch said, I believe. And so in considering that, how should we interpret the Constitution, and is that fact, the equitable interpretation of a public law document, is that a rebuke of alternative forms of interpretation that might be a little more restrictive?
Well, so this sort of reminds me of what I was saying before about how early in my career I thought of the Constitution as a secret code, that could be unraveled with the correct cipher and would reveal all of the correct answers. And then later, I started thinking of the Constitution and constitutional interpretation more as sort of paleontology. So, once upon a time, you could say the dinosaurs of original meaning stalked the earth, and now we're left with these bones and we're trying to reassemble, but there was really a dinosaur, and we're trying to reconstruct the skeleton in the most accurate way, but there is a right answer. And what I was saying before, I understand now as sort of a process of maturation as a constitutional law scholar, is the realization that really there was no dinosaur. There was no original meaning, objectively correct, answering this question that we're trying to reconstruct. We have resources that the past has left us, and those resources might foreclose some interpretations of some constitutional provisions, and they might make others more plausible. But fundamentally, we are engaged in a process of construction, I think. We are building a framework for our nation going forward, and that really should be the focus of what we're thinking about. So yes, we like the idea of fidelity to the past. I think Americans are very unusual, actually, in the degree of devotion that we have to this idea of keeping faith with the founders and the framers. And that's nice, it's part of our national story. But we should understand that this is fundamentally a creative project, and it's not an abstract intellectual exercise, it's an exercise in self-governance. It's an exercise in trying to create a nation that we can be proud of, that will function, and to which we can all belong going forward. So I tend now to think about constitutional interpretation less as an exercise where there is a right answer to the hard questions, that can be objectively proven. And I should say, I think that Justice Souter, for whom I clerked, was a big influence on me in this regard. Sometimes there are conflicts, sometimes there are ambiguities, and it's a test of us to see that whether we can work through that in a way that allows America to work together. But it's also a vote of confidence in us as a nation and us as a people that the drafters gave us this document with these contradictions and these ambiguities, because they believed that we could do it.
Yeah, I think I view the Constitution predominantly as a political document, as creating a framework for politics to happen. And so when we're talking about the ambiguities inherent in the Constitution, I actually think in many ways those are its greatest strengths, because it creates a certain level of flexibility. And I would point out here that on certain issues, the Constitution is not at all flexible. If the Commonwealth of Pennsylvania were to elect a third senator to the Senate, that person would be denied entry into the Senate and say, no, you get 2 senators and you get 2 senators only. Right? Likewise, the government can't just not conduct a census in 2030. No, that has to happen every 10 years. Right? But the Constitution has these delightfully ambiguous phrases like the general welfare and interstate commerce. And then we added on to them with the amendments, right? Cruel and unusual punishment. And then later on with the Civil War amendments, what exactly is due process? And I think that this is, like, to sort of use the cityscape here, like if you look at Independence Hall down there, that is a building made of brick. And you can only make buildings of brick so high because brick is very rigid. But all around us are buildings made of steel, and steel you can build higher and higher into the sky because it has movement to it. It's flexible. And I think that one of the ways that we understand these, the primary way, actually, I would argue, that we understand these wiggle words in the Constitution is through the process of politics, right? And you can see that in the history of constitutional debates. 175 years ago, the major constitutional debates had to do with whether or not the federal government could fund internal improvements. We don't have that debate anymore. Likewise, there was a heated debate over whether or not chartering a private corporation was a constitutional act. We don't have that debate anymore either. You could say, well, that debate was resolved in McCulloch v. Maryland, but I think that actually misses the tail for the head. I think that the debate was actually resolved by the public, and what the court did in McCulloch was acknowledge the resolution of that debate. And so these words and these sort of ambiguities, these flexibilities within the Constitution are determined and redetermined continuously, predominantly through the political process.
Thank you. Our next question is about amending the Constitution. So, under the Articles, it was virtually impossible to amend because of unanimous consent. The Constitution makes it a little easier, but we have not amended the Constitution in 32 years. And many people opine that it's because our Constitution is actually broken. And so I'm curious what that says about our Constitution. Is that an indictment of the document that we cannot amend the people's vision of their government because of so many external factors? Does that mean our system is broken?
I would say no. I mean, I think our system is struggling. I certainly wouldn't deny that. But I would acknowledge the difficulty of what you could call dead hand control, right? A document that claims to be we, the people of the United States, was written, debated, and ratified by white male property owners who have been dead for more than 200 years. There's definitely an issue of dead hand control in a constitution that is hard to amend. However, that being said, I would make 2 points, just at least in terms of considering the nuances of this. I think that one of the fundamental values embedded within the Constitution is the doctrine of consensus. This is the idea that how are the framers trying to solve the problem of majority rule? Because majority rule can be a problem. You can get majoritarian tyranny. And when you take the national republic and you take the system of checks and balances, you start to see this vision of how the framers went about solving, which is the idea that the larger the majority, the broader the majority, the more durable the majority, the more likely the ruling of the majority is going to be beneficial for the national interest. It's not a guarantee, right? Any given moment, the majority could be wrong. Absolutely, even a large, broad, and durable majority, the majority can be wrong. But over time, that's probably your best bet, right? And so when we come to consider changes to the fundamental law of the country, that should be where there is a clear consensus. And I think that is what the amendment process does. It creates a demand for consensus. And consensus, of course, is exactly what does not exist in our country and has not existed in our country for some time. So I think that is something to bear in mind. The other thing I would bear in mind as well is the point that I made to the previous question, which is that we have amended the Constitution many times without actual amendments, right? Like if you look at like the debate over the General Welfare Clause, or take even the interstate commerce clause and how that was reimagined during the New Deal. It was completely reimagined. And we de facto amended the Constitution when we elected Franklin Roosevelt, re-elected him in 1936. The public rendered their verdict on the New Deal, and the Constitution was in many respects changed.
So given that this is a conference on the Articles of Confederation, I'll start with there as essential context, because from the perspective of today, we often say, why did the people who designed the Constitution make it so hard to amend it? From the perspective of what came before, they would emphasize, we made it very easy to amend. The problem under the Articles was it required unanimity, every single state, and that was among the reasons a new Constitution was needed. They really thought they had lowered the bar in a significant way that would permit meaningful, necessary constitutional change when it was necessary. And this was among the many things the Federalists emphasized in the face of constant anti-Federalist complaints, that this new Constitution would extinguish the principles of the American Revolution. You're replacing local government with distant central government. It's not adequately representative. You've set up this unitary executive figure that will have all this power, this federal court system that will pull on appeals process decisions that were made at a local level with a local jury into distant federal courts. How could you have destroyed the revolution in this way? And they're trying to parry all these claims and explain how, in fact, actually what they've done will modify and refine the principles of the revolution. But one thing they come back to over and over and over and over again is, you anti-federalists keep saying the Constitution is imperfect. Of course it's imperfect. Nothing human beings can make is perfect. Nothing we could have made in 1787 could be close to that. How amazing that we've wired into the structure itself through Article 5 means for its own amendment. And some of this is rhetorical, but I also think some of this is a prediction that they think when change will be needed, when the exigencies demand it, the amendment feature is there and it will not bog down like the Articles. Now, as it's turned out, that really hasn't played out as that might have predicted, because again, we see it as much too high a threshold. State constitutions are amended all the time. By comparison, it's much easier to change them. Some people would say, who live in certain states, it's much too easy to change state constitutions. So it's about finding the balance. I guess two things that could just then be said about sort of our defunct amending tradition. On the one hand, some would say, look at the early 20th century, the progressive era, when people really amended the Constitution. There was a culture of believing in doing the work of amending, rather than saying it's just about winning a majority on the Supreme Court because amendment's not possible. But the flip side of that story would say the most important amendments that kind of gave the United States Constitution a new lease on life were the Reconstruction Amendments that were only possible under conditions that could never have satisfied the amendment conditions. It required a war and half the country being thrown out and the surviving winning majority reconstituting the nation by abolishing slavery and establishing new equal rights of citizenship and birthright citizenship and the like that never, ever, ever could have gotten through the amendment process. So there is a complexity there to work through. But the framers, they would have emphasized we had one standard and we made it way easier to amend. They definitely thought that they were creating a path to renewal that would not, this was one of the major reasons the Constitution was better than the Articles.
If I could just say one thing on that quickly. So I think the Constitution is too hard to amend. One of the things the progressives wanted to do, actually, one of the progressive amendments that didn't make it, was they wanted to make it easier to amend the Constitution. And it's absolutely true, as Jonathan was saying, the framers made it easier than it had been under the Articles. And they thought that they were creating a path towards renewal. But again, I think the party system has really messed this up. So the last amendment that we had was this very anodyne, good government, you can't vote yourself a raise before an election intervenes. You could expect bipartisan support for that, sure, because it's hard to imagine that being a partisan issue unless one party is flagrantly corrupt or something like that. But we don't have a party of corruption. For most things that you might want to do as sort of a pro-democracy constitutional reformer, though, there's going to be a partisan effect. So take the Electoral College, for an example. It turns out that the Electoral College doesn't reliably favor one party over the other, but in a particular historical period, it's going to look like it does. So in recent history, it seemed that the Electoral College has favored the Republican Party. The Democrats have been the ones saying we should get rid of it. Go back to 2000, George W. Bush wins the Electoral College, loses the popular vote. John Kerry, then almost in 2004, won the Electoral College, lost the popular vote. With like 10,000 more votes in Ohio, he could have done it. And if that had happened, both parties would have been stung, losing the Electoral College but winning the popular vote. Maybe it could have changed. But that moment passed, and now I think no matter who's being favored and who's being disfavored, the party that thinks the Electoral College favors them is going to defend it. You won't get an amendment. And here's the worst part. They won't think that they're doing it because of partisan advantage. So you can look at the debates out there about the Electoral College. People say things that are crazy, right? They make no sense. They don't fit the facts at all in terms of why the Electoral College is a good idea, but they believe them, right? They don't understand that they are engaged in motivated reasoning, that their partisanship leads them to prefer a particular outcome, and they come up with reasons for that. So partisanship is obstructing our ability to reform the Constitution, and the way that human beings think, we don't even understand that's what's going on.
Wow. So we only have a couple of minutes left on this panel. This panel is called Debating the Constitution. So with all of your historical knowledge, constitutional knowledge, what should the audience take away today about the significance of the Constitutional Convention and the debates that occurred there?
Well, it's a constant challenge. Each generation has to face its own difficulties, and there have been real crises in the past. There have been times when the government was not very democratic. There have been times when we had terrible inequality and terrible oppression. And we did manage to get through all of those. Now, like sometimes it took a civil war and a reconstitution of the American political order. When you have things like that, there are really difficult questions about what you do going forward. But overall, I remain relatively optimistic about the whole American experiment. And I think that is one of the lessons of history. You can look back and you say things were bad in the past, but they did get better. And the lesson that I always try to tell my students to take from this is American history is really a story of people working within the system for as long as they can, as long as they think that it can deliver the results that they need. But if you reach a situation where it can't do that, where the system is irretrievably broken, then the American thing to do, this is not a disloyal thing, the American thing to do is to break that system and make something new.
So right on those lines, it's called, you mentioned debating the Constitution, so that's a central thing to recognize, that at the beginning, there was not agreement, but bitter debate. And there were a lot of people who thought, as I mentioned in my previous answer, the anti-federalists, that the Constitution added up to a betrayal of the principles of the American Revolution. And what those who defended the Constitution said was, we are in a time of extraordinary crisis. I mean, the depth of the crisis of the 1780s was really severe and requires dramatic action. We must do something. But you are wrong that in doing something that appears new, that appears in reasonable ways inconsistent with what we thought we declared independence in the name of, that we have betrayed those principles. We've in fact engaged in the crucial work of learning from experience, of applying the lessons of experience that prior political theorists didn't have, and innovating. So rather than throwing out the principles and concentrating authority as some called for, well, Republicanism had a nice run, let's have King Washington and we'll have law and order again. No, let's revise the system in a way that will seem different and unprecedented that few would have accepted a decade ago, but explain why it's consistent in some deep and real way with what this country is about. And that's, in many ways, what the United States Constitution was in 1787, 1788. It was an enormously creative attempt to construct something new that would not have been considered consistent with what came before and show how it was consistent in the face of crisis. So if we find ourselves in a similar crisis, what will be the great act of sort of innovation to explain how something different than perhaps we've tried is in fact a better way of redeeming those principles?
I think just briefly, I am very impressed by the political tradition in the United States, which is that the Constitution houses the two major parties. And what I mean by that is that if you look at the 1790s, which is really when you see partisanship become very feverish very quickly, both sides believed that they were the ones operating within the constitutional framework. And this is a continuing theme throughout much of American history. I mean, even the great heretic, John C. Calhoun, felt obliged to over-argue, but to justify nullification, which is a profoundly anti-constitutional idea. He felt obliged to make an argument that it was, in fact, deeply constitutional and deeply consistent with the Constitution. And I think today we still see conservatives and liberals and Democrats and Republicans, when they're framing their arguments and they're framing their positions and they're framing their place within the broader political order, they're doing so in the context of the Constitution. And I think that's just a testament to the remarkable durability of this document. That everybody, there's really nobody in mainstream politics who says, oh, like we're against the Constitution. And they're really, I mean, outside of the Civil War, and even then, the secessionists believed that the Constitution had been violated by the North. So it's really a remarkable historical phenomenon to see this document be sort of the thread line through all of American politics. It's really extraordinary.
Well, please join me in thanking our wonderful panelists.